Hello, everyone, and welcome to video 3.2.5 for the Legal Studies guy. Today we're going to be looking at the court hierarchy, which is obviously something we covered in criminal law, and this is just a little bit of an extension on that, but content we should already have a good understanding of. Our quote today from Stephen Covey, no idea who that is or why they're important, but a good quote. I'm not a product of my circumstances, I'm a product of my decisions. Now, let's be realistic, our circumstances certainly do impact some of the decisions we have the ability to make and can make, but ultimately it is that reminder that we do have all have some level of self-agency and do have the ability to try and make the best decisions for us, particularly when it comes to your study in year 12. Decisions are a huge part of how much time you're going to devote to these subjects and the rest of your, pursuits in life, and making good decisions now and perhaps some sacrifices. That's going to pay off in 6 months' time or 8 months' time or whenever exams are. So, as I said today, we are looking at the court hierarchy. And again, just like criminal law, it is the reasons for a court hierarchy. So why we have one, not just what it is, why we have a court hierarchy. But this time, obviously, we're focused on civil disputes. Like criminal law, the study design lists us 2 reasons that we need to learn about. So including we can learn about more, but these are the 2 that are named, and that means that the 2 that an exam can ask us direct questions on. They are administrative convenience, which is a new one, and then appeals. So appeals is just the same as what was in criminal law. Our key skill today is to justify these reasons. So in a way, do more than just explain what the reasons are, but really work to illustrate how a court hierarchy is needed to uphold these reasons effectively. So really provide that, more argument side of things. So at the end of this, you are going to be able to tell us what the reasons for a court hierarchy are in civil disputes. Weird sort of way the Court of Appeal came in there, but look, I've said that the jurisdiction of the Victorian courts is assumed knowledge. Assumed knowledge isn't the right word. You certainly can't be asked a direct question on them, and you're not really going to be penalised for not knowing exactly what jurisdiction each of these courts have. But it is certainly assumed, definitely in the way that questions are posed to you on an exam, that you do understand where each court sits in the hierarchy, that you do understand that the Magistrates Court is the lowest court in the hierarchy, and have a picture of the Horsham Magistrates Court there, which has actually been renovated since that photo. Looks a bit nicer at the front now. And the Court of Appeal within Victoria sits at the top, with obviously the High Court at the top of the Australian hierarchy, and then the County Court and the Supreme Court in the middle. So within civil law, again, it's not necessarily required knowledge, and you're probably not going to be heavily penalised if you get this wrong, on an exam. But it is worthwhile knowing that effectively civil disputes are measured based on their monetary value, and $100,000 is the cutoff point for the Magistrates Court. So if your civil dispute is worth $90,000, that's one you would initiate in the Magistrates Court. Anything below $100,000, and then technically anything above $100,000, but anything at all, you can initiate a dispute worth less than $100,000 in the County and Supreme Court, because they have unlimited jurisdiction. So outside of the Magistrates Court hearing things below $100,000, the County Court and the Supreme Court then have that unlimited jurisdiction to hear anything. So you could take a matter worth $90,000 to the County or the Supreme Court. It is just likely, I believe, the courts would have an ability to force you to initiate that in the Magistrates Court instead, or the fact that you've used up their resources when you had other avenues of dispute resolution available. You had another institution you could go to, being the Magistrates Court, might impact on, the restitution that's available to you at the end. Then we have the Court of Appeal, which only hears, strangely enough, appeals, and they hear all appeals from the county and the Supreme Courts, and then the High Court can hear appeals from there. No original jurisdiction in the Court of Appeal or the High Court. So why do we have a court hierarchy? Two reasons. That should say civil disputes, not criminal. Appeals and administrative convenience. Because we know it already, I'm going to start with appeals. Same as criminal law. Barely anything I've changed in terms of the text in here. If there are grounds for it at the conclusion of a trial, a dissatisfied party, so the plaintiff, perhaps if they've lost or they're not happy with the damages that they're awarded, or a defendant, if they're not happy if they've lost, or again, the damages that they've had to pay, that dissatisfied party can take the matter to another court to have the decision or the amount of damages awarded reviewed. Really straightforward. It would be similar in a school setting, potentially, if, say, a year level coordinator made a decision that you weren't happy with, gave you some kind of consequence. You're not just going to keep going back to the year level coordinator to get them to try and change their mind, because they're probably not going to. You might escalate that and ask for that consequence to be reviewed by an assistant principal. Same in the court hierarchy. You're taking that original decision and asking someone higher up to review it. The justification really comes in here. If there were no higher and lower courts, then there would be no higher courts to appeal to. You'd be appealing sort of across the same level to judges within the same court, judges who effectively then have the same level of authority, and it becomes messy and it becomes, I guess, not as clear and seamless as we have constructed our hierarchy to be. So the justification here is that without higher and lower courts, there would be no higher courts to appeal to. So a court hierarchy, fundamentally one of the reasons we have it is to facilitate a system of appeals. So that can be language that you use. One of the reasons for a court hierarchy is to facilitate a system of appeals. And I've got an example here just to illustrate how this works. Rebel Wilson had a high-profile defamation matter about 6 years ago now. Rebel Wilson claimed that she was defamed by a series of magazine articles that portrayed her as a compulsive liar. Wilson won her trial. It was found by a jury that she was defamed, and the judge in that trial awarded her $4.7 million in damages. So a lot of money, the biggest defamation payout in Australian history at the time. The media company immediately appealed the damages. So this is an important thing about appeals. They were able to take it to a higher court. They didn't appeal the decision. They didn't actually appeal on the basis of whether they had defamed Wilson or not. They effectively agreed with that decision by not appealing it, but they appealed based on the damages, and they just said, hey, it's too much. You shouldn't have given her this much money, because a big chunk of those damages were Wilson saying that she lost movie roles. And as a result of losing movie roles, she lost the amount of money she would have been paid for those movie roles. And the judge believed that would have added up to about $4.1 million. It went to the Supreme Court of Appeal, and 3 judges on the Court of Appeal reviewed the decision of the original judge. So again, system of appeals. 3 judges in the Court of Appeal reviewed the decision of the single judge in the Supreme Court. And those 3 judges, upon review, found that there wasn't enough evidence presented by Wilson and her legal team to show a connection between the articles and losing the movie roles, and as a result, she wasn't then entitled to that money, so she had to pay that back, and ultimately, she only received $600,000 in damages rather than $4.7 million. Wilson actually then tried to appeal this one step further. So it was appealed from the Supreme Court to the Court of Appeal by the defence, and then Wilson, the plaintiff, tried to appeal that to the High Court to try and get the money back, and the High Court said, no, we won't hear it. They basically said, we're not even going to hear your arguments. We don't think that your appeal would be successful. And that was the end of it, because you can't go any further than that. Our second reason is a new one, administrative convenience. Now, this is a slightly different one to specialisation that we learn about for criminal, and you can't confuse the two. So with the risk of confusing you, specialization was all about expertise. So judges develop expertise in dealing with a certain area of law, and as a result, we're going to get the rules applied properly, the law explained properly to, say, a jury, and then the right decisions are going to be made. So we're going to get a more effective justice system, effectively. Using effective twice there. Administrative convenience is slightly different. Administrative convenience is about the distribution of cases based on their complexity, and you could say seriousness as well. So we stream where cases go generally based on how complex they are, and with the theory that matters that are worth less money are generally less complex. Not always, but generally less complex. Matters that are worth lots and lots of money, particularly, say, big business disputes, things like that, the idea is that often they are more complex as a result when there's more money involved. And effectively, what we do is we take the less complex matters and we stream them into a lower court, like the magistrates court. The magistrates court, we know, has more locations. There are more magistrates available. These less complex matters can generally be dealt with quicker. And as a result, our legal system works more. And this is a key word that you should write down for administrative convenience. Our legal system works more efficiently. Okay, efficiently. I think I potentially spelt that incorrectly, but you get the gist of what I'm getting at. Likewise, less complex cases, quicker and hopefully easier to deal with. The more serious and complex cases, they go then to the higher courts, particularly hopefully the really complex ones to the Supreme Court, even though the County Court and the Supreme Court effectively have the same jurisdiction. And they go to the higher courts because they will take longer to hear. They will hopefully then be heard by judges who are experts. So a little bit of specialization crossover there. Just be careful. And as a result of streaming those less complex matters into the lower courts, these higher courts have more time available and more resources to devote to the more complex matters. As a result, the whole system works smoother and better. Similar to appeals, you can use that justification of if we did not have a court hierarchy, all cases would be going to the same court and there would not be a system of streaming them, or there would not be a system of determining or distributing their complexity to make the system as efficient as it is now. So having a hierarchy is more efficient because it enables administrative convenience. Example here, class actions, which we'll learn about in dot point 3.2.8. Class actions are large matters where there's lots and lots of plaintiffs at the same time. An example being the Black Saturdays bushfires class action. These are usually incredibly complex, and in that case, there was thousands. I think it was over 3,000. I could be wrong, but over 3,000 plaintiffs. So 3,000 people who had or were arguing a civil wrong had been done to them. As a result, this required extensive resources to hear. There were 3 associate judges given to the case. There was a special courtroom built. They had to come up with a new file management system because of how many files were involved. The Supreme Court could devote the time and resources to that because we know that the lower courts were dealing with those less complex matters and not clogging up the Supreme Court's time. So this is how administrative convenience is all about efficiency. Again, justify is our task word here. So justify, we have to more or less give reasons for or argue or explain how the court hierarchy how these reasons are directly linked to the development of the court hierarchy and why we have one. So again, might get a question like this: outline one reason why a court hierarchy is used in civil disputes. And the key thing here is this sentence here, which truly illustrates the why. If there were no higher and lower courts, then there would be no clear avenue for appeals. Similar with administrative convenience, if there were no higher and lower courts, there would be no way to streamline cases to ensure the system works more efficiently. So really important to have that sentence in at the end. Principles of justice, making sure that we apply these, fairness, equality, and access. If you wanted to pause now and have a go at filling them out yourself, you could. But they're pretty straightforward with a court hierarchy. Having appeals can help you push your matter to a higher court if you feel you've been dealt with incorrectly, if we've got the wrong decision. But administrative convenience also should mean that judges are hearing similar cases of similar complexity, and they develop that expertise, a little bit of specialisation. But we know, like, appeals can just add extra steps. If a party has money, they might be better able to appeal the matter for the sake of it, if they believe that just the decision's wrong, for example, and it just creates added stress for a plaintiff and potentially limits their access. But everyone has access to appeals. If you believe it's wrong, you've been wronged, you have the ability to continue to access the justice system to have that fixed. So that is access as well. A few details here. I'll post these links below. Just again, court websites are great. Like I've said before with CAV and VCAT websites, court websites are great to give you details about what they can and can't hear in their jurisdiction. So consider going to have a look at those. But other than that, if someone came up to you today and said, "Hey, county court, what sort of do they do differently than the magistrates court? Why do we have different names for different courts?" You should be able to say, "Hey, there's a few reasons for that. They are administrative convenience and appeals, particularly for civil matters, but you can also use specialisation for civil law, just making sure you use civil law examples. So class actions is a great one there. The Supreme Court specialises in hearing class actions as opposed to the Magistrates Court or the County Court. So you can use specialisation here as well. But yeah, hopefully you truly understand what administrative convenience and appeals are now. As always, any comments and feedback below. But we're getting close to halfway through Area of Study 2 and getting close to Unit 4. So the year going quickly. Happy studying, and we'll talk to you soon.